sales amongst the members for business development, and addition of new members and new and enthusiastic members to take forward the Indo-American Chamber of Commerce. Now, I would introduce today's moderator, Mr. Prashant Ajmera. Mr. Prashant Ajmera is a reputed Indian lawyer and Canadian citizen with more than 25 years of experience in the field of corporate and migration law and international trade. His law practice is based on solid foundation of providing honest and accurate legal advice to his diversified clientele who wish to obtain residency and citizenship through investment. Mr. Ajmera holds science degree and law postgraduate degree, and he began his High Court. With additional standing federal letter office 5 years. In 1992, he was awarded a double professional degree from the Institute of Company Secretary and Administration while studying at London School of Business, UK. In 1993, he joined a Canada-based law specializing in residency and citizenship for professional businessmen as an associate lawyer responsible for Asia Pacific region. In 2001, he started his independent practice in Canada, assisting foreign businesses to set up or expand their forward. Mr. Prashant Ajmera, please.
Good morning, Dada Sahab. Thank you very much for a generous introduction. Good morning to all the members of the IACC and the attendees who has joined this morning on Saturday. This is a very unique initiative which has been taken by the IACC Ahmedabad chapter, and talking about the impact of the recent policies on changes in US immigration law and how it has affected our business and education in India. We have taken these initiatives along with the IACC basically just to give an information to all the our members and people at large, because it affects every aspect of our life. Any proclamation or any executive order which is being signed or passed in United States by the President Trump, it affects us. Obviously, every time it makes also a headline in our newspaper. As we all know, the US immigration is a very complex legislation. We all are affected by that. And what we are going to talk about is the various aspects which has happened in this respect in the recent time. So this is how we're going to have the presentation. After my brief introductions, we have a very renowned immigration lawyer from USA, Taiyyeba Safri, joining us from the leading law firm SGC California. Then we have Mr. Shivendra Singh, Vice President at the NASSCOM, who is responsible for global trade development and question and answer.
Lawyer here with us.
Can you guys mute, please? So we can have a problem in making a, whoever is, please, everybody put it on a mute. So as we know, the US immigration, that what are the main category which is affect us? Because each and every one of us who has visited USA, we always looked into the B1, B2 visa, or generally known as a visitor visa. Then the another aspect is the F1 visa or a student visa. Most of the parents wants their children to study in United States, or I can say that this is the most favored destination for the Indian citizens in every respect, for study, for settlement, for doing the business. And obviously the primary aspect which always comes up in the way is the visa. So student visa is the another aspect we are looking at it. Then obviously as we are as a India as an economy, we are leading in the IT industries, and number of our IT professional has settled, and every year number of IT professionals are moving or going to America under the H1B visa, H1B professional visa. Then another visas which we always talk about is the L1 visa, which is intra-company transfer of the employees from India to United States. J1 visa is also the exchange program. Then another aspect which affects all of us, probably every one of us who are here attending this can say very easily that I have my relatives who are in USA, and this family sponsorship is a major chunk of the US immigration, which comes under the F1, F2, AB, F3, and F4 sponsorship. And lastly, but not the least one, EB5, investment category visa, has recently become quite popular. So these are the 6 or 7 categories of the visas we have picked up, because I believe that this one is affecting the most to our lives in every respect. Either we are facing the problems, or our friends or relatives, or somebody is facing a problem on this one. And as we all know that since we have gone into this COVID situation, since last almost 3.5 years, we have seen the number of proclamations or the executive orders or the special orders which was signed by President Donald Trump has come into the picture. And today we're going to talk about each and every one of that which is affecting our visa categories, or in which the Indian citizens are being affected. And it is very important to understand, because every time we are getting into the confusion, probably we are looking at the newspaper, we are asking the immigration agents or consultants or friends, or probably calling United States to our friends and relatives that I'm in this visa categories, do you know what is happening? So in that respect, I think this is a very important session to understand. So before I take much of the time, let me introduce our next speaker. Her name is Taiyyeba Safri Skomra, and she is a partner at the SGG LLP, where she focuses on investors, entrepreneurs, and immigration, family-based immigrations, litigations, and analysis of the immigration consequences of criminal activity. She is a certified specialist in immigration and nationality law through the State Bar of California Board of Legal Specialization. Taiyyeba is admitted to the practice by the state of California, Illinois, and Washington, as well as the U.S. Court of Appeal for the 7th and 9th Circuit. She graduated from the Mount Holyoke College, Magna Cum Laude, and from the University of Washington School of Law. Taiyyeba is from Chicago, Illinois, and she speaks variety of language, including the Indian language. She spends her free time in cooking, sewing, and dancing with her husband and 2 young daughters. Taiyyeba, floor is yours for another 30 minutes. Thank you.
All right. Well, thank you very much, Prashant. That was a very generous introduction. And I'm very grateful to be participating in this event with everyone. And I couldn't agree more about the importance of understanding the effects of all of these proclamations on people's everyday lives. And so I'm really grateful to join you. Thank you for having me. So here is a list of some of the recent proclamations that affect Indian nationals. There have been a lot of other proclamations, but we're not focusing on those today. And so these are the ones that we'll be coming back to, and we'll try to remind you what some of them are, which ones we're referring to as we go on. So the first one is from March 26th, and this was to state that certain agricultural workers would still be allowed to enter the U.S. Because because of the agricultural industries that needed that labor desperately in the U.S. still, despite the pandemic. And then it was important to hear that we were going to still receive visas for medical professionals, even as the consulates were starting to close or had already closed, that people with medical backgrounds would still be priorities for appointments and as on an emergency basis. And that's been, and I definitely know that those are still going forward. there are meteor kind of updates that happened in the following days and months, so we can move to the next one. Then a significant proclamation came through that suspended the entry of a broad swath of immigrant visas. And so this was really important for everyone around the world, and in particular for all of the members of our Indian audience today. So this halted the visa applications for the beneficiaries of petitions by U.S. citizens for their unmarried sons and daughters, as well as for their married sons and daughters and their brothers and sisters. And it also halted the visa applications for the spouses of green card holders and their children. In addition, it stopped the employment-based categories 1 through 4, essentially, as well. And then this was further extended until December 31st, 2020, which can also, again, be extended based on presidential review and proclamation. There are exceptions that can be applied to each of these categories still, and that's important to note. Because people are not completely without recourse if, for example, they have an age out situation where a child would potentially become ineligible for immigrating with the rest of the family simply because of the proclamation. And we'll talk a little bit more about that here. But it's important to note that the people who are still able to be processed are the healthcare professionals, and people coming in under the EB-5 visa that was specifically exempted, the spouses and children of US citizens. You'll note that the parents of US citizens are still restricted. And this is extremely problematic because the rationale for suspending the entry of all of these people is to say that it would be to protect the US economy from people who would be taking jobs from US workers. However, at the same time that they are saying that the parents of US citizens should be stopped from coming in because they could take jobs, they have previously said the same parents are at a higher risk of becoming a public charge to the US economy because they're older and less likely to be employed. So that's a big problem with their reasoning, in addition to, of course, the reasoning that they're protecting the economy when we know that a lot of people in the classes that they're prohibiting could be coming in and generating jobs themselves for US workers. There are some other categories for US forces and things like that who are also exempted, certain special immigrant visa categories. And then, thankfully, it's the cases with the children who are at risk of aging out that could still have some recourse. And the way that that could practically occur is, for example, where a family is in the visa processing stage, or would have been, and they know that now that their visa would become available under the visa bulletin through the final action date, that now their 1-year period has started to try to lock in their child's age. Because a child can only immigrate with the family if he or she is still unmarried and under the age of 21. There is a slightly complicated method of calculating the age for that purpose, which I won't get into, but the point being that there's a method of locking in that age under 21 by completing certain steps, which include paying the visa fees. Or submitting the visa application. And so if the State Department is told that on a blanket policy, we're not processing any of these immigrant visa cases for F1 through F4 and EB1 through EB4, then they would not be issuing visa fee bills as a practice, or allowing people to submit the application. So anyone in a situation where their child needs to lock in the age needs to affirmatively ask either the consulate or the NVC, whichever portion of the Department of State has control of the case at that time, that they need to be able to complete those steps to protect their child and try to include the child. Once the age is locked, then even if the interview doesn't take place, for the foreseeable future, that's okay. The child should still be included under the law. And that's very important for people to be able to advocate for themselves. I count on the agencies reaching out to applicants with children in these precarious situations. You would need either your counsel or to be informed yourself that you have to reach out and ask for an exception. The next big kind of bomb came, and everyone expected it to come. There had been some rumors about not only the extension of the April proclamation to continue the suspension against the immigrant visas, but that they would be adding some kind of restriction to also non-immigrant visas. And to explain the difference between those two terms, immigrant means that a person is coming in to live here permanently as a permanent resident of the US. Non-immigrant means that you're coming in with a temporary purpose. And so these are the specific non-immigrant visa categories that are restricted now under this proclamation. And so this affects the H-1B, the H-2B, and then their dependents, and then certain J visas, not all. So it's really important to remember that not all J's are restricted. And then the L's as well. So L is the intra-company transferees, and that's really problematic for so many companies right now. And of course the H's as well. So in order for the proclamation to actually apply to foreign nationals, there are these three conditions, and they have to all be met, where the person was outside of the US on the effective date of the proclamation, June 24th, and that they don't have a valid visa on that date. And then a week later, on June 30th, House clarified what they mean by that, that it's a valid visa in the category that one seeks admission in. So for example, let's say a person who has an approved H-1B petition, but was outside of the US at the time and does not have an H-1B visa, but does have a valid B-1, B-2 visa in his passport. This, pursuant to the clarification, it doesn't mean that he can enter with the B-1, B-2 visa and then start his H status. If he wants to come in to pursue H status, he would need the H-1B visa. And then the third condition is that the person doesn't have another kind of document that would allow them to travel to the US. And it's important to note here that advance parole is a valid travel document. So anyone who has a pending green card application, the adjustment of status application, then they would still be able to enter the US. And that can apply to a lot of Indian nationals who at one point, perhaps their priority date was current under the visa bulletin that the Department of State publishes every month. And perhaps they were able to file their adjustment application years ago, and they are in a process of continually renewing their work permit and travel permissions while they wait for the visas to actually be current for adjudication. And for Indian nationals in the EB1 and EB2 category and EB3, that can be a many year wait right now. It's also great to note that allegedly under the proclamation, no valid visas will be revoked solely because of the proclamation. They have reiterated that with each proclamation. So that's good. That does not mean though that a visa cannot be revoked for other reasons. So usually that would mean perhaps if there was any kind of fraud or violation of status or even an arrest in the US or somewhere. So, what I've seen frequently is where people are in the US and are arrested for something like driving under the influence of alcohol. And that arrest itself can trigger revocation of the visa. So that's something important for people to bear in mind. Significantly, there are exemptions to the proclamation, and one is for Canadians. And I should specify that means the Canadians who are in visa exempt categories. So, for example, the E2 is for investors coming in for a temporary purpose, and so even if you're Canadian, you still need an E2 visa. But for all the other categories of visas, Canadians are visa exempt. So by its face, the proclamation does not apply to Canadians. And second, there are separate agreements between the US and Canada as to what is considered essential travel between the countries. And so those are what govern. And as of right now, for Canadian citizens, then they can still appear at a port of entry and present their approval notices, for example, an H-1B approval notice, and be admitted into the U.S. That's an important exemption for anyone who might be a dual citizen between Canada and India, for example. So again, on the point of and this is, to reiterate that all three of the conditions need to be met. So if a person, even if they were outside of the US when the ban took effect on June 24th, but they do have their pre-existing valid visa that is for the status that they want to resume, then they are still able to return. And then I believe it was actually yesterday that the Department of State issued an update to say that if the principal, for example, the H-1B or the L1, L1A, person is in the US already and was exempt from the ban, then their dependents could still be processed. And that's a really, significant update, because up till this point, we were under the impression that those dependents were out of luck, and that this would, result in a lot of family separation between principals and dependents. So that's just as of yesterday, they issued the update in how they plan to implement this. And then we have there is this issue of discretion. So when one is seeking an exemption, it will be up to the consular officer to determine if that applies. And this is where, some advocacy could be important, or at least some pre-planning in how to present one's case. Because these are the kind of categories for exemptions that are for people providing essential labor for the food supply chain, and those who would be in the national interest. And this includes those providing medical care and research in connection with COVID-19, defense, law enforcement, diplomacy, national security, and then this is the category that I think could also really require some maneuvering, is those engaged in economic recovery and what that might mean. We've seen anecdotally, we've heard of those who might be involved with facilitating remote work in the IT field as being exempt, and so being able to receive this exemption. And so not everyone is going to get that, because it would kind of be, if they said all IT workers, then it's kind of an exception that would eat the rule in a way if they're trying to protect US workers. But I think that's going to be on a case-by-case basis to see how one could argue that what they're providing is essential to the economic recovery for the US, for stability of remote workers and things like that. So, and perhaps Mr. Singh can tell us more when we get to that stage later in the talk. This was ridiculous what happened on July 6th. By noon, I had several emails from clients who are students in the US, international students, panicking. And because of this new rule that ICE, the Immigration Customs Enforcement, had announced, rescinding their waiver for students to be able to participate in all online courses during the pandemic. So in March, when essentially the government, shut down in most states in the U.S. There were a lot of closures of schools, etc. The ICE allowed this exception to the rule that classes must be at least in person. Only one class can be remote at a time for a full-time student. And abruptly said on July 6th that for the fall that would cease, and that if students were in a program that was going to be full-time online, they would either need to transfer to one that had in-person instruction or leave the US. Thankfully, Harvard and MIT stepped in and in a day or two filed a complaint in federal district court, and it was well supported by all the other schools in the country. Then pretty soon, within the week, states were filing their own lawsuits as well as plaintiffs, because they have state universities that were going to be very damaged by this. People wanted to talk about the contributions of F1 students to the diversity of the curriculum and all of their importance, but it also really comes down to economics, because frankly, these F1 students contribute millions of dollars to every one of these schools. And this was, it would just cause an inordinate scramble for institutions that had been planning for months how to have an online curriculum that would be safe for their students and faculty. And Harvard and MIT were not going to put their faculty at risk just because I said so. So thankfully, the government relented, and a week later essentially rescinded the rule. So students are safe for now. So some of the options that we can talk about for Indian citizens that remain viable include the EB-5 visa. And many of you may already be familiar with it. It is a category of visas for immigration to the US as permanent residents that involves significant investment in a US business, a new commercial enterprise in the US. And the basics of the program are that as of November 19th, 2019, the investment amounts have increased so that the minimum investment would be $1.8 million US, unless the commercial enterprise is principally doing business in a targeted employment area. And what that means is an employment area or a region that is either rural or that has 150% of the U.S. national unemployment rate. So and in that situation where it's a targeted employment area, the minimum investment is $900,000 US. This is a significant increase from the previous amounts, which were $1 million as a minimum, and then $500,000 for a targeted employment area. But what are positive developments within the EB-5 visas to Indian nationals include the fact that as of March 31st, the U.S. Citizenship and Immigration Services, which is the agency that adjudicates the first step of that case, the I-526 petition, that they have shifted their adjudication order to one based on visa availability rather than just, you know, the date that the petition was filed. So it used to be first in, first out, allegedly, but, you know, that would make people who filed in 2018 years behind those who filed in, you know, 2015 and earlier, even though their visas might be available now, whereas the bulk of the petitioners from 2015 and earlier are from China and are in a much longer backlog. So this is an important step for Indian nationals to be able to proceed with their cases. The second is the development that visas are actually current now for Indian nationals in the EB-5 category. So what that means is that their cases can proceed after the adjudication of the I-526 petition to the next step of the visa processing or the adjustment of status if they are lawfully in the US. And, you know, that's been a boon so far. I can say for some of our clients who, you know, were waiting for a long time already for their I-526 petition to be adjudicated, certainly not the, you know, 5 years or anything like one might be in from other countries, but even a year or two. And, you know, we were able to show USCIS, look, their visas are current. You can adjudicate their case. And, you know, and on top of it, they're doctors, and they could be providing services related to COVID-19 if they were free to do so independently of their H-1B employers. Because as you might know, when one is in an H-1B status or an L-1 status, they're tethered to their petitioner. So they cannot do work for outside employers. And, you know, whereas once one has a green card, you know, the person can shift to any employment at any time. And, you know, they're not tied to one employer. So that's yielded some, you know, speedier adjudication, some expedited adjudication of the I-526 petition, and then allowed us to also file the adjustment of status application promptly for these doctors. You know, we don't know still how long the adjustments will take because everything is just slowed down right now. We've seen that slow down since this administration came to power. It's kind of part of their you know, way of reducing immigration overall. And then second, of course, is the pandemic. And so there's been office closures. And now, even as the USCIS offices are slowly reopening, they have limited services, so in limited appointments. And they're kind of prioritizing those who are applying for naturalization right now because they have statutory rights to have their cases heard. And that leads to lawsuits that the government doesn't want to have to fight. Okay, and we can come back to any questions that anyone might have on the EB-5 visa as well, but I do want to mention the other categories here we have, which include the EB-2 national interest waiver. So although the EB-2 category is also backlogged for Indians, but if by chance their priority date is current and they are outside the US, then I think that's a good kind of case to be able to pursue still getting an exception. One, they've already demonstrated that their work is in the national interest of the US. And so it should be a pretty straight correlation to saying that they should merit an exception to this proclamation also based on national interest. So I would be happy to see people proceed on that. This includes people, you know, we see physicians, those are usually physicians in the US who've been able to qualify for the waiver of based on, you know, performing services in underserved areas rural areas of the US, or with other governmental agencies. So that's important that those cases can still go forward within the US, and I would say even from abroad. The F1s, yes, please still continue to pursue the F1 visa if you're interested, because that is not halted. And the O1 for outstanding and extraordinary people in a variety of professions. I mean, the O1s can be in, from artists and, actors and things to researchers and physicians. I've even, I've worked with physicians who are in cancer research, for example, unable to get the O1 visa. So that's something to still pursue. The clinical J1s and research-related J1s are also still being processed. And then, like we discussed, are the positions engaged in economic recovery, which is a good area for argument in terms of how one's position could fit in that category. And then there's the E2 investor visa. Now, India itself is not a treaty country with the US for the purposes of the E2 investor visa. That's, please note that. However, if one obtains an additional citizenship through another country, such as Grenada or Turkey or Canada, then only then could the E2 become an option. It would have to be another country that has an E2 treaty with the US. And then, then there would be the whole E2 process of having a business that is at least 50% owned by the treaty investor, and with the proper business plan. It doesn't have the same requirements as an EB-5 visa in terms of a specific investment amount or a certain job creation requirement. However, it does have to be a substantial investment that's proportional to the business that one is establishing. And if it does create employment, then that's even better. It needs to be more than marginal, meaning it has to exist as a business to go beyond simply employing the investor and his or her family.
I think we come to an end of the presentation. So let me summarize certain things. Thank you very much, Taiyyeba, for your excellent presentation. Obviously, we're going to take the questions, but let me summarize certain things which Taiyyeba has mentioned. Basically, we are looking at particularly the family class immigrations, which is F1, F2, F3, and F4 category is not being processed. So all these citizens who are waiting for the family class sponsorship to USA, that application processing has been suspended till 31st of December 2020. Am I correct, Taiyyeba?
Yes, with the exceptions that we've talked about under, for aging
under
out.
the age out. So under that, say for example, if your child is aging out, you already got the welcome letter from the government that your petition is approved. Now the visa is available to you, but your child is probably of an age and you think that he's going to be over 21 and will not be included. If you are in that situation, then you can ask the USCIS to process your application. And for that, you can take an actions of paying the fees and completing the DS-260 form on NVC websites. Am I correct, Taiyyeba?
Right, but it would not be the USCIS to contact. They would have to contact either the National Visa Center.
National Visa Center, yes.
Or the consulate itself.
Consulate itself, yeah. The second category, what we have is with respect to the student visas we talked about, that we had a big uproar into the U-turn. But as you mentioned in the last slide, that the student visa application is going to be processed as of now for the fall term.
Correct. Yes, as long as the consulates, the Department of State announced earlier this week that they would begin a phased reopening of US consulates around the world, depending on a post by post basis. And what they mean is the consular post, and that would be in conjunction with reviewing the current status of COVID-19 cases in that particular city and area. So, when they destaffed, when they shut down in March, they sent home their staff. All of the Foreign Service officers came back. And so them announcing in, this week that they intend to reopen, one should take that with some caution in terms of the timing, because they will need to restaff all of these consulates. That means kind of repatriating all of the workers, the Foreign Service workers, getting them housing and all of those things slowly. And so, but as that happens, then we should be able to see students be able to reapply for their visas if they need it. If they already have a previously valid visa, and let's say, an F1 visa, but now they've changed schools or something, then they don't need to get a new visa. They can present their new I-20 from the school and still use the previous visa.
So now the second one, the next one is an H1 visa, because obviously that affects the most, and that's where we are most interested because of the IT industries. But now H1 visa this year, they didn't accept any application as of 1st April. And also they are not going to process till end of the year. So what is the impact going to be impact of this one, you think, or where the people they stands on this one? What is going to happen people who are already on H1 visa in USA? Are they going to renew that?
Yes, those people are not affected by this proclamation. So that's really important. And the advice to them by their attorneys will be, don't leave. If they were able to process a change of status incident to their H-1B petition, then they will remain in H-1B status and be able to continue working.
Right. Okay.
To clarify.
Yeah, go ahead, Taiyyeba.
So they changed the process for H-1Bs as of this year. So usually it would be that on April 1, everybody filed their petitions, and then there would be way more than the 65,000 that are allowed, and then they would have a lottery from within those that they received, and then they'd send back everybody that didn't get picked in the lottery, along with their filing fees. This time, what they've done is a registration process from beginning a couple of months earlier, where they say, okay, submit your name and the information that the fact that you intend to apply for an H, and for which beneficiary, and then they conduct kind of a lottery out of that information. And if you're selected from the registration only, then could you pursue actually filing the H-1B petition? And so we're seeing a flip in that process. So there aren't a lot of wasted, efforts in people filing petitions that would be rejected. So those petitions are still being filed right now. And, they potentially, for people who could still be in the US and let's say they were in F1 and in OP in their optional practical training period after having graduated. And so they will get, kind of what's called cap gap employment from the end of their OPT until the start of their H-1B on October 1. So there are still certainly opportunities for those within the US to continue pursuing their H.
Okay, let's conclude at this one. We have another speaker coming up, and then we will take the joint question and answers for both the speakers together. So thank you very much once again, Taiyyeba, for your wonderful presentation. Now our next speaker is Mr. Shivendra Singh. He is heading the Global Trade Development Department at NASSCOM and responsible for global positioning of NASSCOM and the industry. Primary role is to develop, direct, and strategize and implementation of all NASSCOM international efforts regarding market development, policy advocacy, communications, and outreach activities. On the market developments, is looking after the sites, focus, and identifying business opportunities in developed, emerging, and strategic market globally, and implementing a plan to access business opportunity in target markets for the member companies of NASSCOM. The policy advocacy part includes research to evaluate emerging legislative and regulatory issues that may impact the industries and making the appropriate recommendations or action plan to address industry issues in a key focus market for working closely with various stakeholders. He is also responsible for the role entails maintaining the relationship with the think tanks, analysis, embassies, Indian missions, overseas partners, organizations, and country-specific stakeholders, managing inwards and outward delegations from companies and visiting dignitaries. Previously, Mr. Singh has worked as a trade, investment, and policy worker over a number of years, promoting business growth, both strategies and executions, assistance from the global markets into India, and worked on assisting the Indian companies to go global. Previously, he worked as a country head of the for the Scottish Development International based out of British High Commission for 8 years. He is extremely well networked and enjoyed a high profile leadership positions and participated and spoken at various events organized by the CNBC, NASSCOMs, and Economic Times, and a number of Indian market awareness raising events in India and globally on market entry strategies. He has an MBA from University of Warwick in United Kingdom. Mr. Shivendra Singh, floor is yours. Please go ahead, sir.
Thank you so much, Prashant, and thanks Dinesh Bhai and others in IACC for inviting me for the session today. A very good morning to everyone on a Saturday, which is not a bad day to do a session, given that you don't have too many external meetings. It gives me a huge pleasure to come back, to IACC. I remember the last time I was there, it was, in a live session in Mumbai, a few years back. And welcome to the new normal, and this is the new normal that is going to be here for some time. And we will probably need to navigate it. And we're already seeing that we've been able to pivot, quite successfully in this direction. In terms of what I plan to cover, it's always great to, have, lawyers talk before you, because they've paved the way, and Taiyyeba has done a phenomenal job in terms of, giving you a very, very granular guidance and on various kinds of, visas as far as the US is concerned. I will not spend too much of time on that, but I would much rather focus on the policy perspective of it, and the implications and the ramifications that it has from a tech industry perspective, given that I represent the tech industry, and it's not a surprise that more than 75% of Indian nationals get the H-1B capped visas, and about 70% go to the tech industry. So these are two things that we should keep in mind while we discuss this. I'll also attempt to focus on the non-immigrant visa category, which is the visa category which impacts the tech industry, primarily the H1s and the L1s, as we speak. Thankfully, STEM OPT hasn't, been impacted, but I don't think so it's going to be there for long, because the current rule, section 212F, which has been used, is for looking at, preventing people from coming into the country. So, we may see some measures, which come on that. So first and foremost, I think it's important to understand, why does H-1B visa, which is the main visa that we talk about, exist? And it's important to know that the reason for its existence is that they fulfill a very critical skills gap in the US, which has existed over a period of time, and hence they come and bridge that skills gap and make the US economy more competitive, and generate more revenues for companies and livelihood, along with growing the US economy to be the #1 economy that it has been over a period of time. And sometimes, there are a lot of misperceptions which tend to get created primarily because of political reasons and not economic reasons. And I'll take you through why, that is important. And the matter gets further complicated when from political reasons it becomes economic, and from economic it becomes emotive. If you kind of look at the challenges, you can't even give economic rationale to an emotive reason. So, these are a few complexities that you have to keep in mind. Now, over a period of time, we are seeing that, from a US government side or US administration and the legislative side. So for the wider audience here, it's important to understand that there are two kinds of challenges which have appeared over a period of time. The first is the administrative challenges, which is the executive side challenges. And the second is the legislative side of challenges. So, we need to see and view the challenges on these, categories from both the perspectives. And I will give you some examples, as we move forward. But, the big challenges that have come on, on these visa categories, has been brought about by the misperception that, typically the H-1B visas, are brought in because they are cheap labor, number one, because they replace American workers and displace them. And hence, you get a political, in a political climate, which is, for example, now where you have the presidential elections in November. We have seen over so many years that it does tend to, peak during this time. Now, the big problem that we have faced as an industry is that artificial, barriers are also created, which have been discriminatory in nature as well. So, for example, there is an artificial barrier of what we call 50-50 companies, which means companies which have more than 50 employees in the US and more than 50% of their employees are visa holders. And then there are a barrier of what we call H-1B dependent companies, which is people who have more than 15% of their employees on visas. And the tap can open and shut from a government perspective in the US on this, which means that all companies may not be impacted, in the same way, and it does alter the level playing field. And I will come with examples on that. What we have always maintained, and including the government, our government has also maintained that the non-immigrant visas, or how we call it, the high-skilled worker mobility, that is how we define it. Is a trade issue and is not an immigration issue, for the simple reason that you have a specific number of employees or workers who are in high demand globally, and they are, their job is to go and complete projects in different parts of the world, and they are not there to stay. And if they are not there to stay, it does not alter the net migration numbers, of that particular country. And hence, it's a trade issue and should be discussed as a trade problem and not a immigration problem, because the moment it becomes an immigration problem, when you're talking about trade deals and others, then it does not get covered, within those realms. And the fact is that in the current, world scenario where you're seeing increased protectionism, free movement of talent globally is something which is going to suffer and has suffered to a great extent. So I just want to bring you back to the misperceptions of H-1B as cheap labor and displacement. So what happened was last year, there was a detailed piece of research which was done by a leading market research agency called IHS Markit, which looked at the Indian tech industry and looked at their economic contribution and the economic impact and the H-1B and the wages, and came out with a lot of data, which was a combination of primary and secondary research, which we released in the US in Washington. And I just want to give you a few snippets of it. The Indian tech industry contributes nearly $57 billion to the US GDP, which is more than the GDP of 5 individual states in the US. So I think it needs to be seen from that perspective. The hiring, local hiring of the India tech industry has increased quite a bit because of change in business models, digital transformation, needing to have domain expertise. They hire nearly 500,000 direct and indirect, and from an indirect perspective in terms of employees, and that's been growing as such. In terms of wages, these companies have been paying about an average wage for the computer system occupation for about $96,300 dollars compared to the average overall wage, which includes local hires, for about $94,000 odd dollars. So it's definitely not less. So I think, and then the top 7 companies from India or India-based companies, which take up more than 90% of the visas, their visa consumption has declined drastically, to about 5,500, in FY19 from about 16,000 4 years back. And they take up, a very small percentage, under 10% of the overall capped visas. So you can imagine, and the rest of them are taken by US companies. But the important point here is that 75% go to Indian nationals, which is a testimony to the fact that Indian nationals have the requisite skill sets to be able to meet these requirements, stringent requirements which companies are looking for, and they fulfill the critical skills gap. So I think this is something which is very important to understand, and clear from a misperception perspective. Now, I would want to shift to the challenges, because that is what we are here to discuss today. As I mentioned in the beginning, these challenges are from 2 sides. One is the US administration challenges, which in the current administration, to be honest, has been quite a bit, in various ways and forms. But I will take on 2 of those challenges. One, which is the one that we've been talking about, for the last 3 weeks, which is the second proclamation on the non-immigrant visas, which as Taiyyeba mentioned, impacts a number of categories. But from our interest, it impacts the H1Bs and the Ls. And there is a temporary ban on the same till December 31st, 2020. Now, if I look at it in terms of the impact, in terms of numbers, as Taiyyeba mentioned, the people who are already in the US, it's not impacting them. And people who are in India also, but who had a visa, valid visa issued before the by the 23rd of June, can go to the US on that. So it's not retrospectively being impacted. The other one is from a realistic perspective, because of travel restrictions, we do not expect, travel to happen before September for any way. So the new H1B visa season, which comes in from the 1st of October till December, is an impact that we do think, will be felt. And we have requested, that this visa ban should not go beyond, this period, because otherwise you will see a huge impact. Now, let us look at the objectives and, behind this whole exercise. Because it's been done at a time when there are challenges with increased unemployment during the COVID recovery period, and there are challenges to the economic growth. And this is the economic rationale which has been provided for imposing this proclamation. When I look at the reality and the numbers, it points to the other way. It's definitely not true. So it does not stand on a strong economic wicket. And why is that? So, if you're looking at unemployment figures, the unemployment rate for the computer occupation, which takes up most of the H1B visas, have come down from 3% in January 2020 to 2.5% in May 2020. So it's coming down. whereas the overall unemployment numbers have definitely gone up from about 4% to 13%. So it's important to know that there is practically near zero unemployment as far as the occupation that we are talking about is concerned, where you get H-1B visas. The other startling fact is, as of May 2020, there are 625,000 active job vacancies in computer occupations, which is the area where H-1Bs come in. Now, at a time when the unemployment is growing, but at the same time there are such a high level of job vacancies, clearly points out to the fact that the skill sets which are currently available or who are unemployed are not being able to fulfill this job requirement, and hence you need a different skill set, and it provides us very, very strong endorsement that that this demand for the skills that is being which is there is not being able to be bridged. So I think that is something which needs to be kept in mind. Hence, our view on this is, and we have gone public on this, is that this will have a negative impact on the US economic recovery, as well as it will harm job creation in the US. And this is not just NASSCOM's view, but this is the view of other associations like US Chamber or NAM, or even the Senate Judiciary Committee Chairman, Lindsey Graham, said that it is going to create a drag on US economic recovery. So it's a pretty strong corporate America reaction to it, and you are going to see, litigations, and we've already started seeing litigations which are being filed on this issue.
Yes.
The other one, which I just want to bring to everyone's notice, which probably does not get discussed enough, but can be a bigger challenge, is the proposed regulatory actions which are going to come in, and this has been discussed for some time, but this is going to come in, as we are told, as early as probably the end of this month, where we are talking about eliminating the H-1B lottery and looking at the wage levels in determining the grant to the to the H-1B. The other one is looking at the definition of specialty occupation, employer-employee relationship, looking at changes to the client testimonial to be able to justify them using H-1B visas, and these are all long-term actions which can be taken, again ostensibly on the ground to protect local workers. Now, this is something which we feel has a very strong potential to alter the level playing field, and it will be a huge challenge to the whole system, and we must all keep this in mind while we are navigating this challenge, because the other one hopefully remains temporary, because it's a temporary ban, and we hope that it doesn't cross December. But the regulatory actions or proposed actions are something that we must keep in mind, because this is going to be the bigger challenge, and and it's coming as what they call in legal parlance as interim final rule, which means that no one will have a right to comment on that, and it will straight away get implemented. And again, there is talk of litigation on this also, and we will see how this pans out, but it's an issue of concern. From our side, Taiyyeba talked about the exemptions and the national interest exemptions which are there, and it's very restrictive in nature. Our demand has been that tech workers should be granted exemptions as essential workers based on not our definition, but US Department of Homeland Security's definition, what they call the CISA guidance, Critical Infrastructure and Security Agency guidance. Under that, they have various roles within the tech industry, tech roles which they classify as essential workers. And our view is, please look at those roles, and and DHS is very much an integral part of this decision making, and grant exemption to tech workers as essential workers. Now, why is this so? If you look at the tech industry and its role, and I'm so proud to say that the tech industry is performing even more a critical role in the COVID recovery period. If you look at whether it's managing critical infrastructure in the hospitals, whether it's working towards development of the vaccine, whether it's cybersecurity, whether it's online education, And all of that we are doing today is all, related to how the tech industry has pivoted and is providing that critical service. So it's important to consider the role as essential services and, be granted exemption. So we will see, how that moves forward, but, this is something which is, worth considering. On the legislative side, we also see some challenges, and there are two legislations, which I must bring to your notice, which is the S3770 and S386. The first one is a bipartisan bill, and both of them talk about specific action to be taken, against 50-50 companies, and even barring 50-50 companies from, taking up, H-1B visas. So while they are, they have not passed, or, they are still in discussions, but we are closely following them because this is something which can have a, adverse impact. And lastly, on the administrative side, I just forgot mentioning, but one of the things which is important to understand that there is a USIS proposal which is looking at reviews, but this is talking about additional visa fees on extensions for the 50-50 companies. If you remember 2016, when this was levied, when our Prime Minister spoke to President Obama those days, the visa fees, additional visa fees went only on 50-50 companies for the new visas, which was amounting to another 4,000 and 4,500 for H1 and L1 visas. Now they are trying to propose, they're proposing it for extensions, which again will have a huge impact on 50-50 companies and alter the level playing field. So that is something which probably may come in because they are reviewing the submissions on that, and that may also happen as we speak. So to conclude, I think the fundamental fact is these visa categories are bridging a critical skills gap. They are not cheap visas, and they fulfill a very important role on the whole US economic growth story. And it's not the Indian companies which take up all the visas, it's Indian nationals who do that to a great extent, but that's a testimony to their skill set, and these are some of the points which we as an association, work with our government closely. We work in the US with, key people and in Washington and the administration and the legislative side. And we do try and, sensitize them of these facts, but it's an uphill battle. And, we will need to see how this pans out. It can, if this gets extended in some way, I'm already seeing an increased interest in Canada. We did the first online trade mission to Canada because I wear two hats. And, we saw a huge increase in the interest in doing work in Canada and the Canadians are wooing us in huge ways. So, like never before. So, that is something which we need to look at. There could be a potential increase in offshoring, but at the end of the day, if till the time that this skills gap gets bridged, which we are working on, we have something called a future skills program where we are looking at 10 technology areas, including AI, robotics, machine learning, 3D printing, cybersecurity, blockchain, IoT, and others. And we are looking at working with various people across the world to ensure that we get the new skills, because 60 to 65% of the existing skill set in next 5 years will not be useful. And the entire world needs to work together to do that. And if we are able to do that together in the US, there is no need for H-1B visas. But till that point of time, the skill sets are not bridged. This is important, and it should be seen as a trade issue, as I repeat, and not as an immigration issue. And I'll end my talk here. Thank you.
Thank you, Mr. Shivendra. Thank you for giving us a perspective. So you mentioned about the litigation. I think Taiyyeba can reply on that one. As I understand, Taiyyeba, that on H1 visa, there is a litigation just started by a group of about 147 H1 holders. So what is that about, and what are the arguments they've taken in their petition, in the litigation?
Yes, there are 2 lawsuits now pending that I know of. And one is this one that you mentioned with the 174 Indian nationals. And it's by a firm called Wasden Banias, which is in South Carolina. And, so that's going to be important to see how that develops. That's specifically for people who are kind of in H-1B status and stranded outside the US at this point because they had gone home for some reason and were unable to get their visa appointments as the consulates closed and have been unable to return. The arguments that I have not been able to access the complaint in that case, but the overall arguments I expect to be very similar to the other case that's also pending in Gomez versus Trump. And that's also pending and that's actually being put through by a very large law firm called Mayer Brown, and in conjunction with the American Immigration Lawyers Association. And so the arguments in that complaint, which have been made public, are that this is essentially exceeding the president's authority under the section that Mr. Singh mentioned of 212F, and that this basically violates the Administrative Procedures Act, which is how rules have to be promulgated, that there's a process for it, and that this just violates all of those expectations that people have of the kind of law and order of how our administration processes these cases. And then the third would be under the due process clauses of the Constitution. So those are the main arguments in that case. That the Mayer Brown case involves 23 plaintiffs, I believe, with a variety of backgrounds. So it includes a company that has an H-1B worker that of Indian origin whom they can't bring in, and as well as a lot of family petitioners whose cases are stuck. People whose spouses are in another country and can't come in, and as spouses of permanent residents, and all the family-based categories. They've done a really good job of kind of showing a cross-section of the kinds of people being affected by this, which includes also all of the diversity lottery applicants. That, of course, it doesn't include Indian nationals, but the Mayer Brown case is all they filed an amended complaint just, I think, yesterday, actually today, July 17th is the date on the complaint. So in order to accommodate the new proclamation, because it was filed against the first one. And so, yeah, I think we have a lot to still wait and see of what comes from the Wasden Banias case, as well as Gomez versus Trump.
Thank you, Taiyyeba. There is one good question coming from Purvi Chodani, I think, and that question is going to Mr. Shivendra. You mentioned about the various challenges being faced as not as an immigration issue, but a trade issues. So is any specific steps being taken by the NASSCOM and as an organization to do some kind of a lobbying directly to the US government, either at the trade office here in India or in United States in Washington, DC? What NASSCOM is doing, or what is the strategies in coming months or coming time?
Mr. Shivendra Singh, just for the information, Purvi Chothani has been our Western India Council past chairman, and she is also an immigration lawyer.
That's right. And
No,
I know Purvi ji very well, and that's why I mentioned the name. Please, Shivendra ji, go ahead, sir.
No, I know Purvi well, so absolutely. So I think as NASSCOM, this is something that we continue to do on a very ongoing basis. So whether it's, as I mentioned in my conversation, whether it's engaging with the legislative side and updating them on the role of industry and the economic impact that it gets created, right down to a granular level of the economic impact in various states. Because at the end of the day, for a legislature, as well in India as anywhere else, it's important that you talk about a state level impact, whether it's jobs or whether it's investments or overall, and we continue to do that. Similarly with the administration as well, as and when we get an opportunity, for making any kind of a submission, we do that. And in this specific case, we were closely, seeing what the other US-based associations were doing. And I think for a lot of us, the demand was, looking at granting an exemption to tech workers as essential workers under the CISA guidance, DHS CISA guidance. And this is something that we had done. NASSCOM was a signatory to an ITI, which is a US-led association, on this whole IT workers as essential workers, which had included the roles mentioned by the CISA guidance. So we have done that. So all of that, continues to be done along with our government as well on a day-to-day basis, and we continue to follow it up because, it's an important one for the tech industry as well as India, because let us look at the numbers here. Out of $191 billion industry that we're talking about, nearly $147 billion is exports. And out of that, US is about 62%. So it's a pretty substantial number. And the tech industry is about 8% of India's GDP. So it's important that, this industry tries to navigate this challenge as seamlessly as possible, because there are adverse impacts if it does not. And we all need to work together to sort it out. The other one is, from a client company perspective, Indian tech industry works with more than 75% of the, Fortune 500 companies, majority of them being American companies, and enables them to grow and create more jobs. So there is a pretty strong, testimonial to this. So we do work and highlight these on an ongoing basis.
Thank you, Mr. Shivendra. And Purvi has just messaged me to thank you and answering her question. The another question was coming from going to Taiyyeba. The gentleman is asking question about the F4 category. Are these categories still we can make an application, or the sponsorship application can be submitted, or that is not allowed as well?
Yes, you can still submit a petition. That's that's not in the authority of this president to stop the petition process. That's an act of Congress. Yes.
Right, so that can be submitted. And now if you are waiting in for the family class sponsorship, you already got your welcome letter, you already got your DS-260 is done. So obviously now you have basically you don't have anything but to wait from the Indian consulate to open for your interview. That's what is this was one of the questions coming from that. One of the attendees waiting on that question that for the family class application, he's just waiting. So do you think that within how much time it is going to open up?
That's hard to predict. It's going to be based on the status of the pandemic in the consulate, in the area surrounding that consulate. So whether they're getting their process in Mumbai or elsewhere, it's going to be dependent on the pandemic.
Right. So tell me about one thing that, as we mentioned in your presentations and we read it, that the family class sponsorship, which makes the largest number of the green card issued by the American government out of almost 1.1 million, and also the people, the Indian citizens who are waiting in America on EB1, 2, and 3 visa categories, they are not going to be processed. That we understand from that. So at the end of the...
Actually, if they are in the US, they can still proceed. If their category is current under their priority date, they can still proceed with an adjustment if they're eligible.
Right. But so at the end of the, as the so many, my question is that if so many categories of the immigrant visa is being stopped, there's no, I don't think that at the end of the year, they're going to complete the necessary quota in each categories. Do you think that those categories or those unused quota would be allocated to the other categories which is open, or what they're going to do it?
Yes, that's typically what happens, is that there's a very complicated system of how the visas get allocated, and I don't pretend to be an authority on that. But it's exactly what you're kind of suggesting, is that the unused visas get transferred elsewhere. But and I mean, I guess the problem is that the EB-5 is still statutorily capped at 10,000. So, if that's really the only main category that's remaining open, those visas, I suppose, could potentially go unused through that fiscal year, which we've never seen happen before. But that's certainly something I'd want to follow up on to be able to give you a better answer.
Right. So there is a possibility that visa can be used for the other categories which is open up. So probably the EB-5 categories and other will benefit out of this one because it's not being used. But also, the continuously since the new administration has come into, President Trump has talked about, and recently again when this student visa policy was withdrawn, is talking about the merit-based immigration to USA, similar to what we have seen in the UK, Canada, Australia, and New Zealand. What could be the possibility of that kind of an immigration coming up in the near future? Anything substantial development on that, or it's just another tweet?
Well, that would require a major act of Congress.
Right.
And so right now we have still a very divided Congress. We have a Democratic controlled House, and we still have a Republican controlled Senate, and we're in an election year. And so just as Mr. Singh mentioned, this is political, and I don't expect to see a major overhaul like that coming in the next few months, especially given everything else that Congress is going to be dealing with, with the pandemic and the bailouts and stuff. But if that were to resurface, then it's not going to be in this term, I would expect, because, and hopefully it would be, under new administration. So
I just want to add to what Taiyyeba said, not from a legal perspective, but this is something which has been discussed for some time. Now, it's linked to merit-based advanced degrees and US education. Now, who decides as to what is the merit? With all due respect, there's a bureaucrat who's sitting behind a desk, looking at visas, maybe 30 seconds for one visa and judging that? Or is it companies who are going to hire these people and they know that that's the skill set they require? So for example, would a PhD in computer science be a merit-based person, or would a crack data scientist be a merit-based person? Now, when you ask a company, you will see that probably the data scientist is in higher demand right now. And hence, our view is that merit-based decisions should be in some way or form having the involvement of companies who hire these individuals, because at the end of the day, they are the ones who are bringing them based on the needs and requirements that they have, and you cannot superimpose in some way or form a kind of a decision which may not align absolutely with the requirements of the corporate world.
you're absolutely right.
There is one question coming from, I think he's not in a position to join, but send us a message. A gentleman is having a green card. He came back in August 2019. He is staying here in India and is not in a position to go back. And he is out of USA for more than 6 months. And that is, I think, scenario with not with this one gentleman, but number of families across India. What is the Taiyyeba, your take on this one with the immigration authority? Are they going to let them go, or are they going to issue a notice that why we should not take away your green card?
I mean, no, it's really to be seen, because those people haven't been able to effect a re-entry yet. But my expectation would be, especially for permanent resident holders, that there would be leniency on this issue, their inability to travel because of the pandemic. I think the greater problem, though, is this gentleman, it sounds like he hopefully obtained resident status without any conditions. The problem is for those with conditional status who have to rely on these temporary stamps as proof of their status. For example, in the EB-5 category, where the 829 petitions are pending for a few years. And so we have a lot of clients in that situation right now where their stamps have expired and they're abroad. They have no proof of their ability to be able to return to the US. And for them, there are still some measures though too, to be able to get a travel document once the consulates reopen, or to unfortunately potentially have to reapply through a special, it's called a special resident visa, the returning resident visa. But for this gentleman, I would expect that simply having been gone for, hopefully less than a year, that they would not be leveling charges. It's a broader inquiry. So, what the person would also want to be showing, what the other Indian nationals will want to show, are their ties to the U.S. What were do they have a job there? Do they have a home there? Do they pay taxes in the U.S.? How did the current circumstances kind of become unexpected as their reason to extend the stay? And then also, what's their travel history like? Is this the first time that they're suddenly having an extended stay? Or do they always have a very long, like a 5-month absence? They come and touch into the US briefly and they leave again. So it's going to be a case-by-case basis for all the people who've been outside for a long period. But hopefully for a lot of them, it's going to be a smooth re-entry.
Smooth re-entry. What we are talking about, we have Rajalakshmi Rao, who is National President of the NASSCOM. Welcome, ma'am. I saw your tag that you've been watching and listening to us very carefully. It's obviously we'd like to have your blessings and a few words. We'll really appreciate if you can say a few words. So please go ahead.
It's a wonderful discussion today. All of you have spoken so well and to the point. There was so much clarity and so much takeaway from this webinar. I'm very impressed the way you've all conducted, very needed, because all of us are confused. Each one has their own situation. Each is different from the other.
Yes.
So no one thing is right. But whereas you and along with, of course, others,
Shivendra.
Can't get her name correctly. I missed.
Taiyyeba.
Beautifully. All of you spoke so well. Excellent. I think I must congratulate our Ahmedabad, the Gujarat IACC for organizing this. And I was very hooked onto it. It's very nice. I have also a lot of questions, but these are all personal questions. I will not put it here, but I will reach out.
Right.
Thank you very much.
Thank you very much, ma'am.
No. Can I say now that all the experts are there, if somebody is investing a lot of money in US,
right,
and developing in health sector, because she said something regarding the COVID research and all that.
Yeah.
If somebody is doing in health sector, can they really get a lot of visas on that basis? And they're also investing.
Well, the difference might be in the, there's the investor visa that's the E2. They can't apply simply as an Indian national to get that temporary investor visa. If what they're pursuing is in this other category for permanent resident status, yeah, that could be a really good potential for a plan.
Sure.
But setting up those businesses and having a credible plan that's backed up with concrete actions takes time, and so that's might be hard to set up so fast to be able to deal with this current proclamation and the ban that it's caused.
They've got land and everything. They're putting it all together. It's a wellness thing. And so they need to get a lot of visas because a lot of people have to work besides, the American citizens, also Indians who can bring it there. 5
investments, though, they don't count as towards the job creation, those who would be here on H-1B visas. So that's not going to necessarily help with the H-1B problem in that, there's kind of a problem in terms of the interests of the people involved where, the investors need to be able to show that they're employing US workers and not H-1B workers for them to be able to get their green card.
Thank you. Thank you. Thank you, Rajalakshmi Rao. Yes, Pankajji, please go ahead if you have questions, and if you don't have a question, we'd like to have your blessings with your few words, please.
first of all, congratulations to you and both the speakers, Taiyyeba and Shivendra ji. My question is to Shivendra ji specifically. First of all, I would like to extend compliment to him for delivering an excellent talk. My question to you, Shivendra ji, you just stated that after some time, around 2/3 of our IT workforce, the skill sets of the IT workforce get obsolete. And you have been working on the emerging technologies like artificial intelligence, robotics, IoT, etc. Can you tell us more precisely what kind of programs are being run and what are the efforts are being made by NASSCOM on these new emerging technologies?
Thank you, Pankaj. I think absolutely this is something that we've been working for about 3 years. And about 3 years back, we started working on the future skills. Because if you remember, NASSCOM over a period of years has a background on working on as a sector skills council. So we represent the IT sector skills council from an NSDC perspective. So we realized that we needed to look at the new skill sets based on the needs and requirements of the industry. And I can very proudly say that we are the official partners to the government of India. In fact, the Prime Minister, our Prime Minister inaugurated the whole platform. Where what we've done is we've looked at specific areas of technology, areas which I mentioned, including AI, robotics, machine learning, cybersecurity, IoT, blockchain, and others. And we've looked at 75 job roles. So it's not just looking at just a technology, but 75 job roles within these technologies and about 155 skill sets that are required to be able to meet these requirements. And what we've done is we've not developed our own content, but we've collated the best content and curated them. It's what we call a future skills platform, which is launched. It's an online platform. Initially, it was done at a B2B level, so a lot of member companies, participated in it. From early stage learning to deep learning is what we are looking at. So someone who's interested amongst employees would look at it, and then algorithms kick in to say that this is what they need to focus on, and suggestions come in. We also have subject matter experts who do the guidance. So it's a pretty robust and an evolving platform. And now, we've been given the mandate, as I said, by the government to, let's say, if there are about 4.3 million people who are employed, how do we upskill half of that in the next 4 years? And hence, it can't just be on a B2B level. So we're now tying up with colleges and some of the others. It's a very, very ambitious program, but a very important, critical one, given the fact that a lot of the work that is being done, we talk about digital transformation, bundling of technologies. We talk about various elements of it, but that can only succeed from a demand side if you have the supply of that kind of talent. So we are working on that. As I said, we've had a bit of a head start, and we have been discussing this with various governments, including the British government as well as with the US. As you know, in the US, it's more a state-wise discussion that you will probably need to have, given the education sector. So, there are lots of conversations that are happening, but I think the critical thing is that all of us need to work together to ensure that we are being able to upskill people to meet the requirements of tomorrow. And we all know that traditional education system has not been able to do so. We are all, traditional education systems around the world have been 5 steps behind the needs. So what to do is to be able to predict those needs through analytics and be able to develop that, and we are doing that work, and thankfully, although the targets are very ambitious, we are working to achieve those.
Thank you, Shivendra. Thank you. Daga Sahab, are we concluding or we are taking more questions? Please, your call, sir.
One more question I have once Dinesh Bhai completes.
Ji. Pankaj ji, go ahead, sir.
Again, the question is to Shivendra ji. Shivendra ji, you have just now stated that unemployment rate in US is around 14%, but there is an increasing demand of IT professionals in America. And if this proclamation continues, USA is going to lose, not the Indian companies. But what we have been discussing here and in Indian media and newspaper and all professional circles, that Indian IT companies are going to hit by this change in the US law. And if we just look at, I don't know whether the effect will be seen in the following quarters, but the first quarter of 2021, financial results of all IT companies are exceedingly well. So can you just throw some light on this?
Yeah, Pankaj, I think you've asked, two questions. One is, related to the results and how that's the tech industry is performing. And then maybe a linkage to the performance in the US. See, in terms of overall performance, we are seeing that there are green shoots where the tech industry has been resilient and agile. And we are seeing green shoots, let's say, in a few sectors, BFSI to be one. Even including the US besides Europe. So, yes, there are challenges in sectors like aerospace and, retail, hospitality and others, but there are green shoots, which are definitely there. I think the industry has pivoted in overall terms, and you will see that, there are going to be focus on new technologies like virtual workplace technologies, increased cloud migration, cybersecurity, and even digital transformation in some of these areas. Health is going to be more and more focused. When we did a research with companies, more than 80% companies said that offshoring as a strategy is going to be even more entrenched going forward. So yes, we all know the challenges are enormous, but I think the first quarter results, if that is anything to go by, it has shown good signals. It's not gone into negative growth rate as is expected, but it is going to be a bit of a long haul, I must say, and we will see how it pans out. Coming to the US and the unemployment numbers that you talked about, the fact of the matter is that there is increased unemployment. Although that has overall come down also in the US. So, it's always an evolving numbers game, and that's also come down. But, in the computer occupation area, the overall unemployment, in fact, declined between January and May. And there are, 625,000, job vacancies. Now, this is all, pointing to the fact that, while there is an increased unemployment, those people who are unemployed are not being able to fill these jobs. My point is, if they are not being able to fill these jobs, this is a clear justification that the skill sets which require by these jobs are not available. And that is where H-1B visas, play a very critical role in bridging those skills gaps. It's not an Indian tech industry issue, I must point out. It's an issue. It's a global tech industry issue. So, all companies alike, whether it's US companies or Indian companies who take up visas, on non-immigrants, are being impacted. And everyone in one voice, whether it's Sundar Pichai, whether it's Tesla CEO or, across the board, even our CEOs, Indian tech industry CEOs have highlighted to that. So, that's the point.
Thank you. Thank you very much.
Thank you. Thank you, Shivendra. Thank you, Pankaj ji. Dinesh ji, you had a question?
I think, yes. No, I'm okay.
Okay. So I think he has covered the point. So we are concluding this session.
Yeah.
Thank you very much, Taiyyeba. Thank you, Shivendra ji. Thank you, Raj Lakshmi ji Rao, Bora Saab, Daga Saab, and all the members and who have joined from across India on these sessions. The sessions we have recorded this one, so it would be available by tomorrow or by Monday on a YouTube, and we will share with the members which can be seen. Also, the presentation, we would like to put it on a slide share, so that can be seen as well. So it would be a kind of a good reference for people to refer to it. And on the last slides, we have shared the numbers of the our Ahmedabad branch of Indo-American Chamber of Commerce. So if you wish to reach out to the chambers for a membership, If you are interested in joining us in our Chamber of Commerce, what we do this kind of a program on a regular basis, and we continue to do that one. And obviously, if we have more members and more members joining us, it would be better for us. Also, we would like to see that the member come up and ask that certain topics they would like to do it. Apart from immigration is always a hot issue, interesting issues that and is affecting directly or indirectly our lives. But other issues, what we are dealing with the US trades, doing business in USAs, those issues, if you can suggest to us, probably it will give us an idea, and we'll try to arrange a similar kind of webinars in future. With that note, thank you very much. Thank you, everybody. Yes, Daga Saab, obviously you have to conclude that, sir.
And as a part of our, memento presentation, we have loads of love and affection for both the speakers and the moderator. And that is what we would like to share with you. Please accept our gratitude for all your time and efforts. Thank you very much.
Thank you.
Thank you. And have a dinner at your home. Lunch at your home. Thank you. Thank you, guys. So we're concluding this session. Taiyyeba, thank you. Shivendraji, thank you very much.
Yes.
Purvi, thank you for all your questions. Sir Raji Lakshmi Raoji, once again. Bora Saab, thank you very much.
Thank you.
Thank you.